Mic check, mic check. Mic check, mic check, mic check, mic check. Cool. What's that? What's that? Let's close all that. Got the Constitution. Nope. Let's do Declaration. Constitution. YouTube. What's up, everybody? What's up? What's up? Let's What's up, everybody? What's up? What's up? Mm. What's up, everybody? What's up? There we go. 1, 2. Let's do. Let's pull up some dictionaries. We got that dictionary. We got. Is that? That's two. So let's pull up one. Let's do technically, we need to do Francis. We'll do 18. What's up, everybody? What's up? What states are we from? What states are we from? What's up, everybody? What states are we from? Mandamus. We got one, two, three. I need to put that back up. What's up? New York is in the house. New York is in the house. Cold, snowing. Trying to pull up some stuff, then I'll get started. Um, I worked in New York last this year, or there's a brand new year, but I worked in New York out of Elmira, Horsehead, and outside of Albany, 47 degrees. Oh, that's cold. Yeah, that's cold where we at. We in the South. We cold. All right. I'm trying to see. I'm just gonna pull up some dictionaries, and if y'all got questions, oh, you live in Long Island. Oh, you got all the. I bet it's super cold there. You got all the. Um, I'm trying to figure out which dictionaries I need. Oh, that's what I was looking for. Sorry, I'm trying to pull up some dictionaries here. Um, 1890. Virginia's in the house. Let's see. What y'all got any questions? What's up? We can before I pull up some stuff. I like to be a little just in case I find that other dictionary, so I guess I'm not that great at it. Uh yeah, the first, let's do my Francis. Francis. And we're gonna do blacks. Then we're gonna do blacks. Fourth. All right, we'll stop there. I like to explain due process. The more I learn this thing called law, the more concept of due process. It needs to be a cuss word to these people. Let me pull up some due process stuff. Anybody on YouTube? Anybody on YouTube? Somebody's on YouTube. Let's see here. Yeah, we'll just read some due process stuff to get started. If you guys got questions, I don't know what I'll tell you. I don't know. Notice, hearing, and then judgment. There we go. Uh, the Supreme Court of Rhode Island said a search warrant shall describe the persons or things to be seized. They said that statute that declares this. Oh no, let me get it right. They said a statute is void only so far as it conflicts with the Constitution. They said one portion of the statute may be declared unconstitutional. But they said the warrant that was issued for the seizure for nothing. The other thing is in conflict with the Rhode Island Constitution. They said, "Therefore, that statute is null and void." And then they over the issue, what made it void. They said he said that there was any such opportunity given any person who has an interest in the things on the search warrant, that he has any note of any allegation of the facts necessary to exist and warrant a forfeiture. So they said, "Did you even put any of these things in the warrant? Did you put or was he notified that they take his stuff before there was a trial over the issue?" Because they said that's a violation of due process. Did he have any notice of any allegation? Did somebody allege something that was wrong that you can show up with a fake piece of his property? You see the significance? They said this stuff is against the Rhode Island Constitution. Why? Because I bet 1,000 bucks I never read the Rhode Island Constitution, but I bet Rhode Island's got in there, you can't take people's stuff, their life, their liberty, their property without due process of law. And then I'm sure there's a Supreme Court from Rhode Island Supreme Court that says they got the phrase from the Magna Carta in the year 1215. And that and even in 2026, that same phrase meant what it meant in the year 1215. You can't just write fake pieces of and take stuff without bringing it to the jury. You're not supposed to prescribe punishment before the jury has had a time to judge the law and the facts concerning the issue and the evidence that's been presented to them. So they said, "Can it be said that any such opportunity was given to a person who y'all brought a fake piece of paper, talking about y'all gonna take his stuff in a notice that he was subject to forfeiture or any proceeding against his property himself?" They said, "We think not." They said, "No such allegation was anywhere made or to be made. There was no complaint provided that the property was to be divested of without any trial, without any charge." They said they didn't even charge him, and they just took his and they just took his stuff. They said upon which alone he could legally be divested. They said without any such notice or intent or intended trial or inquiry. They said trial or inquiry. What's inquiry? That's when the grand jury shows up and says, "All right, let me see what you got. We'll see if we'll proceed with the case." They said, "You didn't do none of that. You just took his stuff based on a fake piece of paper. So you're not supposed to be doing that." So that's the Supreme Court of Rhode Island. Then we got Ohio. Ohio, the Supreme Court of Ohio said it's very obvious that everything is not therefore deemed to be the law of the land or due course or due process of law. They say anything that the legislator magically writes down is not due process. They say it's against the enactment of new laws, which there's no such thing as new laws. They said it was against the enactment of new laws which ignored proceedings according to the course of common law. They said the protecting shield of the Constitution was so again, they be writing fake stuff that presupposes to take away rights, life, liberty, property. They said you can't do that. It is a very obvious thing that whatever the legislator writes is not due process, is not law. It's not the law of the land, the law of Ohio, the common law of England. So they say you just magically write stuff that takes people's rights, especially before a trial. If there's a lawful injury, if there's a lawful complaint, and then after the judgment, then you can render say, yeah, he hands on somebody, okay, after the trial, he gets dealt with. If he damaged somebody else's property and he couldn't afford it, okay, then he gets his stuff taken. but not before, because that would be a violation of due process. And actually, even if somebody created an injury and they due process, they do an injustice to the injured party because they have to dismiss the case for violation of due process. So they have to retry the case, which takes more time. The Supreme Court of Illinois said an act of the legislator is not the law of the land. So whatever this dude writes or these people write, don't be law. They said a state cannot make anything new law by its own legislation declaring it to be. They said, "Oh, yeah, so it's the law." Get our attorneys to harass people and tell people that they're the law. That's the law we just came out with. They said an act of the legislator which transfers the property to another without his consent is not a constitutional exercise of legislative power. They said it deprives a man of his property without due process of law. A due process. I say this all the time. They say they deny that they do admiralty every day, but they use the phrase in rem, right? In personam, they be speaking all type of Latin in our face. And then so we don't have to say common law all the time. We can just say due process. We know that the legislature can't just magically write then that would be so we don't have to say the Magna Carta, we don't have to say the common law of England. We could just say due process. You didn't follow due process because it presupposes to take away rights by the act of a pen. And a statute doesn't have right. A statute can't testify in court. A legislative enactment can't be injured. You hear all the time, "Oh, well, the state was the injured party. Didn't make a complaint against me." You did. You got an injury. Without a injury, you made a false accusation against me. The state wasn't there. The state didn't make a complaint. You said a statute was violated, not that a complaint was filed. And the purpose of the courts is for the redress of injuries, not violations of a statute. There's no such thing as violating a statute. So the Supreme Court of New Hampshire said that certainly this does not mean this thing called due process does not mean anything which the Assembly of New Hampshire may choose to pass. They say, "Yeah, we pass laws every day. We're not supposed to be here every day. But we in here every day just writing stuff, just taking away rights." They said that does not mean due process of law. That is not the law. They said that the law of the land within the meaning of the term as used in the Constitution of Michigan is a law that hears before it condemns, which proceeds upon inquiry and judgment after trial. Say after trial. See, that's an important 2 words right there. When is punishment supposed to be happening? After trial. See, they be punishing people before trial and then still expect you to go to court and try to fight over it after they've already pronounced the judgment. You took my stuff. What are you talking about? That's a violation of due process. Uh, Supreme Court of New Hampshire said, "If deprived of liberty or property, it shall be by an impartial judicial authority after trial and judgment." Booking, fingerprints, all that is a violation of due process. Yep, yep. Actually, I have that. Let me see if I can pull that up. I got one that says fingerprints is a violation. Fingerprints, photographs. I think it was photographs if it wasn't fingerprints. Fingerprints. Let's see. No justification for fingerprints and photographs. Same case, New Jersey said it. They said there is no justification for taking fingerprints, photographs, or other methods in advance of conviction. Say after trial. They said they're not supposed to be doing none of this stuff. So the Supreme Court of Indiana said that the guarantee of due process of law is to prevent the state from exercising by any of its departments arbitrary capricious power over persons and property. What I did when I was arrested and into jail. Well, it depends on what you were taking to jail on. But I'm nobody's attorney, and I don't know the situations or the facts of your case. You probably need to take it to the lawful judges of your state. So the Supreme Court of Indiana said that the guarantee of due process of law is to prevent the government. It's restrictions. What is, I got a Supreme Court case that says the Magna Carta puts restrictions on United States Congress. What do you mean the Magna Carta puts restrictions on the United States Congress? It says this is to prevent the state from exercising any of its departments. How many? The legislative, the executive, the judicial, arbitrary, capricious power over persons or property. They said the law of the land or due process of law cannot be taken to be the very act of legislation which deprives a person of his rights. They said there are rights in every free government which are beyond the control of the state. Texas says that. They say that I read this all the time. They got an explanation of their Texas Constitution, and they said that the sovereignty of the people of Texas is beyond the power of the government. They were explaining I don't know about the Texas Constitution, but I think it was like whatever article, whatever they say that Texas is a free and independent state, and then they give a commentary on that, and the Supreme Court judge cited that, okay, well, that means that you have a right that goes beyond the power of the government. Uh, the Supreme Court of Minnesota said, um, so they said to give this clause of the Minnesota Constitution any value, no person shall be deprived of any form of legislative or governmental action. A law which extinguishes rights of property or compels their extinction without any legal proceedings whatever comes directly in conflict with the Minnesota Constitution. Read, you say you're from Florida, you need to be reading the Florida Constitution. You need to be reading the Florida Constitution. The Supreme Court of Minnesota said that due process of law requires notice, hearing, and judgment. These words, due process, do not mean anything the legislator may see fit to declare to be due process of law. Say it again. We this is like the fifth state we've read tonight. They said, okay, the legislator can't just magically write things and presuppose to take away people's rights. They said that it's not possible lawfully. They said this thing, there are certain fundamental rights which not even the legislator can disregard. They said one of these is notice before judgment in all judicial proceedings. They said that police power expressed in an ordinance, what's that? That's a state statute. is subordinate to the Minnesota Constitution. I got a lot of stuff on Minnesota. I guess I'm supposed to talk about Minnesota right now. They said Article 2 or Section 2, Article 1 of Minnesota Constitution says that no member of this is supposed to be the it shall be deprived of any rights or privileges secured to any citizen unless by the law of the land or by the judgment of his peers. They said no person shall be deprived of life, liberty, or property without due process of law. They said that by due process of law, this is Minnesota again. They got a problem with the legislator in Minnesota now. They said not merely the act of the legislator. Other cases talking about taking people's alcohol and stuff, but here they just got an issue with the legislator. You can't just be writing everything. It said due process of law means not whatever the legislator may think of. They said the true interpretation of these constitutional phrases that concerning rights, there is no power in any branch of government to take them away. Where rights of property are admitted to exist, the legislator cannot say they shall exist no longer. You know how crazy these statements are? They do this every day. They violate this every day. Maine. Maine got a lot. Let me see what I can read. The Supreme Court of Maine said, according to the Maine Constitution, in all criminal prosecutions, the accused have a right to be heard by himself, demand the nature and cause of the accusation, and have a copy thereof, have a speedy, public, impartial trial by a jury of the vicinity. That's a very specific word. That word from the Magna Carta. They said that he shall not be compelled to furnish or give evidence against himself. So how does this happen? How do we what they say, "Oh, well, they've been violating our rights for years." No, they ain't been violating everybody's rights. They've been violating people's right to furnish evidence, give evidence against themselves. It's not all of them. They say it takes two to tango. They said if we didn't know who you were, you wouldn't even be in front of us. Talking about, "Oh, they didn't have jurisdiction." No, they got it. You went to that DMV, asked for a state ID. "Oh, you want me to sign right here? Oh, you want me to" "Oh, but they did it without consent and consideration and" yeah, you considered it while you waited in line 3 hours at the DMV. They don't make it a pleasant experience. It's never been fun. I've never been in and out of the DMV like that. It's a horrible experience because it's only supposed to be for people who are getting paid to drive, who work for the government of the state. But our ignorance, which we never wanna talk about, we never do anything wrong. The government just magically got all these powers one day. I'm reading all these Supreme Court cases where they not supposed to be doing stuff, and then we say, "Oh, well, they do it." Okay, well, whose fault is it? Say, "Me. It was my fault." That's what I can't get nobody to admit. If we could get 3 people to admit, "You know what? I went to the DMV," we'd be further along by now. They ask all the time, "How did the people of God stay in the wilderness for 40 years?" They wouldn't admit that they went to the DMV. Uh, said that the law of the land as used in the Maine Constitution does not mean the act of the legislator. They said if such was the true construction, then any branch of government could at any time take away life, liberty, or property and privilege without a trial by jury. They do this every day. I just told you how to correct it. You gotta start reading the Constitution. I'm not an attorney. You have to know the law. Can't nobody be there. have to rearrange your life. You're gonna have to get out a pen and a pad, and start buying books, and you're gonna have to start being, what the Bible say, diligent. This don't happen in 3 hours. This don't happen on a TikTok live. You got to rearrange your life, because if I ask you, "Are you driving a car today?" and if you have a state ID, 9 times out of 10, the answer is yes. And if you're not in a position to get rid of that thing tomorrow, then you gotta be quiet and listen until we're in a position getting out pen and pad, because you can't just believe me or nobody. You can't say, "Oh, the black guy on Constitution Academy said." Nope, I can't be there. You gonna have to know this. So you're gonna have to go to your constitution. I know Florida. You're gonna have to go to the Florida Constitution. You're gonna have to go to the Massachusetts Constitution. You're gonna have to do the homework, because I don't know if you know this, nobody's coming to help us. Well, the main constitution, or the main Supreme Court said, "This law of the land thing does not mean whatever the legislator may." They said this branch of government could at any time take away li that means if it could, then that means at any time it could take away life, property, liberty, privilege without a trial by jury. They said this thing called the 29th chapter of Magna Carta said that it had been borrowed to be incorporated in the federal constitution and in most of the constitutions of the individual states. They said Edward Cook said that no man shall be deceased unless it be by the lawful judgment, and that is a verdict of equals by the law of the land and by due course and process of law. So we keep complaining about the judges, but we never went to the judges on these issues. Most Who are the judges of the states? They said the law is something that is permanent, uniform, and universal. They said throughout this country, no person can be taken or imprisoned. This is a guy named, I think his name is James Fighting Kent. I think he wrote the first commentaries on American law. So I think his name was James Kent. Uh, and you read a lot of these cases and they cite him for a lot of stuff. So this dude is giving what they would consider the first commentary on American law. And he says that throughout this country, no person can be imprisoned, disseized of his freehold, liberties, or estate, or exiled, or condemned, or deprived of his life, liberty, property, but by the law of the land, the lawful the judgment of his peers. He said these words come from the Magna Carta. They said throughout this country, everyone is protected by this thing called the Magna Carta. They said the words law of the land means by an indictment and presentment of good and lawful men. That was the grand jury. Then they say the same thing, and then they cite another author, and they say, "By law of the land affirms the right to a trial according to the process and proceedings of the common law." It'll be wild. All right, the Supreme Court of Massachusetts. They said these terms, due process of law, it should be annoying. It should be a cuss word. Oh, due process. No, don't talk about that. Always talking about that. Yeah, that's one thing we're going to talk about. Said these terms cannot mean law of the land at the time of the trial. They said because that may be altered by the legislator. They said and intended to prohibit the making of any impairing the ancient rights and liberties subject of law that they're dealing with. They said under such construction, wholly nugatory and void. They said the Bill of Rights was established on the ancient proceedings by our ancestors in England. the settlement of this country, and the immigrants themselves and their descendants had no safety in the Magna Carta for their personal rights. New York. New York said the same thing. They said, according to our New York Constitution, they said the phrase law of the land or due process of law, let me read it right. They say to say by the law of the land or due process of law may mean the very act of the legislator which deprives the people of their rights, their privileges, their property, leads to a simple absurdity. They say it would be absurd to say that the legislator could just do these things. They do them every day. It is absurd. It's absurd every day. You hear people, and I'm sure if you live in New York, they tow everything down there, I bet. So they said the New York Constitution then would mean that no person shall be deprived unless the legislator shall pass an amendment. They said that's not what that means in the New York Constitution. They said then this means that the legislator can pass a law to effectuate the law. And this would be throwing the restraint entirely away. They're like, then what restrains the legislator? If he can write magical things that are supposed to take away people's rights. They do this every day. They said the true interpretation. Oh, that's going dark. The true interpretation of these constitutional phrases is that there that where rights are acquired by the citizen, there is no power in any branch of government to take them away. They said not by they say this. I'm not just making up. I'm not emphasizing something. I'm reading this verbatim. They said not by an act of a legislator. They said the cause or occasion for depriving someone of his supposed rights must be found in the law. It cannot be created by a legislative act. I just told you. That's not the law. What's the law of New York? Let's do it. What's the law of New York? You know, New York talk about this. I'm telling y'all. Actually, I was gonna read this yesterday. Let's get in a little trouble. Let me teach y'all about New York. Let's go to the Constitution. Let me read this to you. All right. This is the story of New York. This is the history of New York. This is not the beginning. This is where I screenshotted the book. They said New York, like Massachusetts, at all times determined to suppress the Roman Church. What do you mean, Roman Church? They said New York, like Massachusetts, at all times. They're talking about when New York was a colony. They said New York, like Massachusetts, seemed at all times determined to suppress the Roman Church. And an act passed at the beginning of the last century, so that was at the beginning of the 1700s. They said in an act, yada, 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 it declared that every Jesuit and popish priest who should continue in the New York colony after that whatever day should be condemned to perpetual imprisonment. And if he broke out of prison or escaped and was retaken, you had to get rid of him. They said so little was the spirit of toleration and the rights of conscience understood at a much later period that one of New York's historians a half a century afterwards gave this exclusion warm praise of being worthy of perpetual duration. In the Constitution of New York in 1777, they required all persons naturalized by the state to take an oath of abjuration of all foreign allegiance and subjection in all matters ecclesiastical as well as civil, This was doubtless intended to exclude all Catholics who acknowledged the spiritual supremacy of the Pope. When I tell y'all New York did not play back in the day, New York did not play. He said they got rid of them. Why? This thing we're talking about. This thing called due process. New York said that the law of the land does not mean an act of the legislator which can deprive privileges or property. This would be an absurdity. Where did they get that from? They got that from the Revolutionary War. They said these people took over Great Britain's parliament. I got in this book. I read it all the time to y'all. These people called the Jesuits were born in England, but ordained by the pretended jurisdiction of Rome. They said in a pretended, under a pretended act of parliament. What does that mean? A fake legislative act. They allowed these people who were ordained by the Romish church to write fake statutes and take away people's rights. This is literally what due process fights. They said people are writing fake laws that go against what we now know to be constitutional law, which is really just a brief of common law procedure. And as a result, they can just write anything and just take away people's rights and their property. They do this every day. So they said, New York said, uh, they said the cause or occasion for depriving someone of their rights must be found in the law because it cannot be done by a legislative act. They said the legislator can't just write whatever here. They said they tried that in the early 1700s and they used to get rid of them. You understand how serious that is? You know what I mean by get rid of, right? They said they used to get rid of them. They said, no, you can't just write whatever here and take away people's rights. I told y'all when we go over the common law of England, you got King George the First, King George the Second. Well, they weren't English. They were only the King of England by blood. They weren't the King of England by nationality. They weren't born in England. They didn't speak English. They spoke German. They were German nationals. They by blood became the King of England, and because they gave legislative sovereignty over to the British Parliament. British Parliament, people, the Jesuits, the Roman Church, started writing fake laws and started taking away people's rights. They would issue out fake citations. Sound familiar? And then they would bring people instead of in front of the jury, they would bring you in front of a priest in a black robe, and he would pronounce judgments. So New York said any person who acknowledges the spiritual supremacy of the Pope in all matters, ecclesiastical and civil. They said ecclesiastical law only works by citation. You study ecclesiastical law, they said this thing, these people, these scammers on the internet, they talk about equity and all the your negotiable instruments and your and all your fake stuff. Okay, well, all that comes from ecclesiastical law. Ecclesiastical law works by citation. You know what a citation is? I got it in this book too. Citation is witchcraft term. Citation is designed to have you summoned in front of somebody who does magic or witchcraft. They said, here we go, here we go. Not gonna get it in time. Oh, maybe I get it. Maybe there we go. What's a citation? A citation is a summons to appear. What the cop say? He'll give you a ticket and say, "Hey, you can go ahead and pay it, or you can go try to fight it in court." What that mean? That means citation is a summons to appear before a priest in a spiritual court. That's a legal that's not a law that's in every law dictionary. They said this is according to the ecclesiastical courts, which proceed according to the course of civil law by citation. They said before when they declare independence from England, that anybody who does this, you have to let it be known that you acknowledge the spiritual supremacy of the Pope. We'll keep a list of you guys, and if you violate this thing called due process, they would get rid of you. And that was the law. They say you couldn't just write magical stuff or issue out fake citations, and instead of going before the lawful judges of New York, which would be the jury, the people, the New Yorkers, they would bring you in front of a guy in a black robe who practiced ecclesiastical law. Everything they do is a ceremony. They call them tribunals. They wear black robes. They chant Latin. That's all them. So everything you complain about the courts or about these issues, yeah, that's the result of us not knowing our history, not knowing our heritage. So they said, uh, at the Constitution of New York in 1777, they required everybody who was naturalized. What does naturalized mean? Not born there, because everybody started moving to the states. So they said everybody is essentially a foreigner, and so everybody who comes to the state, you're gonna have to take an oath of foreign allegiance. That you're not coming here as secret agents for the Pope and trying to invade our land and act like you're enforcing magically law, and they can take away our life, our liberty, and our property. We're in a war over this right now, so we're not putting up no foolishness. When I say they got rid of them, they got rid of them. They literally were in a war. They said they started dropping bodies in 1774, so they weren't putting up with no. And then you get to so where was I going? I was going to New York. What's the law of New York? Let's go to New York. Does this make sense? Does this sound like somebody telling the truth? Because these attorneys ain't gonna tell you this. They lie about everything. Because they the ones they talking about. uh, what's the law of New York? Yeah, they said this is the Supreme Court of New York. They said we're just using New York as an example. This applies to all the states. We're just the feds don't tell you this stuff, so you can only learn it through the state Supreme Court cases. So they said the common law that was in effect in New York on 1875 continued to be. So when they talk about this due process thing, okay, that's the law. That a legislator can't write magical fake laws and take away people's rights and tow their cars, bust out their windows, and put people in handcuffs and make them sit in jail for weeks and months without payment, without a trial. They said the common law of England that was in effect on April 19th. I forgot. We looked this up. 1775. April 19th, 1775. I forgot. The Battle of Lexington and Concord. They was banging it out before the Declaration of Independence. They was getting to it. They said, "No, we not with it. We getting to it." All right. So they said the same common law we had at that day banging it out. That's the one. They said this provision was included in the first Constitution of New York through every constitutional revision since. They said if somebody got rid of it, then they are foreign invaders or foreign agents who acknowledge the spiritual supremacy the Pope. They said that, another case, they said the fundamental right to a trial by jury is guaranteed in the New York Constitution and includes a right to a jury of 12. Express provisions of our Constitution should be vigilantly enforced and the right to be zealously guarded. They said there's no language in the Constitution of New York that permits a felony jury trial of fewer than 12 jurors. The right to be tried by a jury of 12 is inviolate and cannot be waived. They said there's never a time you should ever have been going to a guy in a black robe, and they call it a crime. They said it can't be waived. They say you can waive it every day, don't they? So if you want a bench trial, you can go and get you a bench trial. They said it can't be waived. People waive it every day. So both people are breaking the law. They said based on the New York Constitution, Article 1, Section 2 says that a trial by jury is inviolate forever. Why? Because at common law, the jury were the judges. I got this other thing. Who are the judges of New York? I read this all the time. This is in they're talking about this is New York talking about a British colony case, a New York colony case in 1735. They said in 1735, the issue of a jury's right to decide questions of law arose. This guy was charged with a libel. At his trial in New York, Alexander Hamilton argued to the court that the jurors had the right beyond all dispute to determine the law and the facts. They said they have the power. They said New York trials, yada yada yada. It is the jury's duty to be governed by the instructions of the court as to all legal questions, but they have the power to do otherwise. They can do what they want. They said the jury are the judges. They said it's inviolate and it cannot be waived. So there's not one time you should ever be in court and a guy in a black robe determines your life, your liberty, or your you know how crazy that statement is? They do it every day, don't they? They done took over. They said in a criminal prosecution for a lot this is another case. They said in a criminal and that was in the '90s, that wasn't in 1847, you know? That was in the '90s. They said in a criminal prosecution, the jury shall have the right to determine the law. Who determines the law, y'all? Does the attorney determine the law? That's not what they said. Does the guy in a black robe determine the law? No, he's not in charge of the law. You are. They said the jury has the right to determine the law and the facts. They said in every criminal case, upon the plea of not guilty, the jury may indeed, they must take upon themselves the decision of the law. They said in every case. They said these case law is irrelevant. These people aren't judges. They said, yeah, oh, this is the Supreme Court of New York. No, 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 no. When you're there, that's the Supreme Court of New York. When you have a real injured party, you have a real grand jury, you have a real trial by jury, you're the Supreme Court. They said in every criminal case, the jury may, and indeed they must, take upon themselves the decision of the law as well as the facts. They said both the law and the facts are so involved that the jury are under an indispensable necessity to decide both. Who are the judges of your state? You. I was well, I have a barbecue every weekend. Call it the judge's barbecue, and not one bar member will be allowed there. And I tell them that you guys are the judges of the law and the facts. If there's no injured party, you don't convict nobody. Y'all ain't ready. Y'all ain't they said, "Who are the New York?" The New Yorker. What states are we from? What's up, everybody? What's up? What's up? What's up, Denise? Some states. I'm like, oh, you talking about New York? No, I don't live in New York. I'm not from New York. New York got some nasty cases though, bro. They teach you some stuff we didn't know. Illinois. We're the judges of Illinois. They say the same thing. It's in the Illinois Constitution. I can never find Illinois. Judges of Illinois. The Supreme Court of Illinois said the trial for criminal offenses, according to the course of common law, the rules of evidence of the common law shall be binding upon all courts and juries in criminal cases. Juries shall be cases judges of the law. Actually, I have this. You go to the oldest. Oh, perfect. You remember the other day we were looking up the definition of a judge? Okay, well, they said in the oldest definition of the word judge as applied to the United States Constitution, they got this thing called jurors. It's a public officer appointed to litigate questions according to law. This includes officers, not only but justice and jurors. Who's the judge? You're the judge. Have a barbecue this weekend and tell everybody you're the judge. That's how you're supposed to do it. Jesus literally told us to do that. He said, feed people. He literally gave us the example. He said, feed them free food, tell them the truth. That's what he said, do. He said, the Supreme Court said all trials for criminal offenses are to be conducted according to the course of common law. Okay, well, at common law, who are the judges? See, they don't teach us this stuff. At common law, which is just a time period, you'll see all these things, they'll say at common law, like they're not supposed to be doing it today. You're supposed to be doing it. They said at common law, they had two types of courts. They had what they call the court of the king's bench, and those were the commercial courts. That's where the sheriff come from. They talk about this thing called a common law sheriff. See, it's a lot of bad information on this internet, and I'm not saying I got everything figured out. I just noticed that a lot of people lying, a lot of people wrong. That's all I know. I don't know everything. I don't presuppose to know everything, but it's a lot of bad information. I don't know what to do about the mic, YouTube. I'm sorry. I tried everything. It never worked. I'm sorry. But they got this thing called the Court of the King's Bench. And unless you had a contract, unless it was a corporate issue, unless you had an actual corporation, you never got brought into their courts. That was for the king's business, which was a corporation at the end of the day, right? So they called it the crown. And I got a bunch of evidence. And then you have what they call the court of common pleas. Where were the court of common pleas for? That was our court. So they said, okay, well, this is where the jury, the grand jury, the injured party, and they said that, and this is all in the Magna Carta. They said, okay, well, a sheriff, a constable, those are all terms. Now, I will say, the ancient word of sheriff is from the Anglo-Saxons. They took that title and they applied it commercially, so it's no longer a common law title. So we see that wrong, and that's not what I'm trying to say. But at the court of common pleas is where you had your injured party, your grand jury, your trial by jury. And in the Magna Carta, they said that a sheriff, a bailiff, a coroner, because they all meant different things then, that they didn't have the power to bring somebody into court without an injured party. Actually, I can pull it up. Imma tell you what it says. Michigan government has the Magna Carta on their website. Let me see. No shit there we go. No, 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 no. Almost, almost. Sheriff. No sheriff, constable, coroner, or other bailiffs of ours shall hold pleas of our crown. That's the pleas, the court of the king's bench. That's where they hold pleas. That's where you go. A plea is where, or a pleading is fake paperwork sent to a and so they said no constable, no sheriff, constable, coroner, bailiff, those would be the sheriffs and the deputies or the police or the peace officer. They said they couldn't just go around accusing people and bringing them into court. They couldn't just hand out citations talking about you ran over the speed limit or you missed a turn or a turn signal and bring people into court and bring them before. They said this stuff is as old as the Magna Carta. They got another one where they say they can't be taxing people. It says immerse or immerse. I don't know how to. Immersed. Immersed. No free man shall only be immersed for the offense according to the measure of the offense. Uh, yeah, they shall only be immersed according to their peers. They said if the peers, who are the peers? That's the jury. Couldn't do it. All right. So who are the judges of Illinois? That's the point. Now the point is the sheriff couldn't, or the deputy, or the police officer couldn't create a case. Do you understand that? They couldn't just magically create a case. It had to be an injured party. It had to be on what they call a presentment or a grand jury indictment, and during that time, and that's what it's supposed to be here. So they say all criminal offenses are should be according to the course of common law. So they say you couldn't call something a crime at common law. The Magna Carta is the epitome of the common law to people. So there's no time and you'll find in the Magna Carta where they could just fake accuse people and bring them into court. He said, no sheriff, no bailiff, no coroner shall hold peace to the crown. You can just go around accusing people and bringing them into court, especially when you are supposed to be protected. So they said this thing, according to the courts of common law, the rules of evidence according to the common law shall be binding on all courts and juries in criminal cases, and juries shall in all cases. Mm, that's a nasty statement. How many cases? They said criminal or civil. How many cases? All of them be the judges of the law. They ain't never told us that, y'all. They never told us that. And I told you they got this word vicinage, right? I told y'all about that earlier. Yeah, I don't know how to spell it. This, this, we got uh, Liberty. Let's see if I can find chapter 29. That's not it. They updated it. Freehold. No free man shall be taken in prison, diocesed, or outlawed, or exiled, or in any way harmed, nor will we go upon or send him save by the lawful judgment of his peers or by the law of the Lamb. They said that judges in all cases, civil or criminal, they say, "You, the judge." They said the jury shall in all cases be, they say it twice in the same case. They say the juries in shall in all cases be judges of the law and the facts. They said recognized by the decision of the court in this case, and it has been the recognized law of Illinois for more than 103 years. The judges of Illinois, who are the judges of New York, who are the judges of Ohio. They said a defendant in a criminal case has the right to be determined by 12 impartial jurors. Percentage, but I can't. There are no judges. That's your fault then. Every time I hear somebody complain, oh well, they don't do this and they don't do that, and then you just complain about it. Okay, well, whose fault is it? Oh, it's the government's fault. Okay, well then it'll keep being the government's fault then, and they'll keep having their way. I can't do it. So they say it again. The jurors in all criminal cases shall be the judges of the law. They said only in criminal cases, but they said in all cases. They said, and again, in another case, they said, "The juror in all criminal cases shall be judges of the law." They said the circuit court was wrong in telling the jury that you are the judges of the law and the facts of this case. You are not bound by the opinion of the court as to what the law is. There are real judges. I'm telling you who the real judges are. The people born in Illinois, the people who live in Illinois are the real judges. They said the same question rose. And again, it was said the jurors in all cases shall be the judges of the law. They said this power is conferred in the most unqualified terms and has no limits which we can assign it. Who are we? The guys in black robes. Why? Because they have no authority over the law. This is in all 50 states. They said the jurors in all cases listed as yada, yada, yada. They said, and being judges of the law, they are not bound by the law as given to them by the court. I said again twice. They said they can say that they know the law better than the court. They have the power to do so. Yes, sir. Exclusively Illinois. That asks ignorance right there. That means we ain't been reading our Constitution. They said this in the Illinois Constitution. They said, we're not telling you nothing new. This ain't new facts. This has been like this for 103 years. They said, "Uh-oh, ignorance issue just arose. Ignorance, ignorance." They said, "Why y'all ain't been being the judges?" They said, "We gave you the Second Amendment. We gave you they can't take your property without lawful judges of judgments of your peers." Whose fault is it? Say it's our fault. What California law said, I got you, I got you. California is nasty. They don't uphold that though. Whose fault that they don't uphold that? They keep saying they're not the judges. But they don't let us. Okay, whose fault is that? California, California. The Supreme Court of California said that the jury has the undisputed power to ignore the evidence and the law and to acquit if that is what it chooses to do. Let me read it again. The jury has the how much power? Undisputed, y'all. It's not up for debate. It can't be beaten. They said the jury has the undisputed power to ignore the evidence and the law and acquit if that is what it chooses to do. They said in a criminal case, a jury's acquittal is final and absolute and irreversible by trial and appellate courts. What? What do you mean, California? They say, yeah, we're going to the beach. I don't know what you're talking about. There's no inter-party. What are you talking about? Yeah, we're going home. See, back in the day, they didn't put up with this foolishness. Everybody worked for themselves. They had farms. They weren't going to their boss. They had stuff to do. They didn't just allow fake cases to come. They say, you're wasting our time. They said a criminal case. What they say? In a criminal case, a jury's acquittal is final and absolute and irreversible by trial and appellate courts. Who has the power to appoint the jury? The I don't know how California does it. Every state would do it their own way, but, the sheriff, or a sheriff deputy on behalf of the sheriff, finds and sends out notices to the jury. And you, if you're the accused and whoever the, plaintiff is, would have the opportunity to interview the juror before appointing them, I believe. But that would be those are like local court rules. You don't those aren't like every court has its own rules. Every court building has its own rules. So remember, the guys in black robes are in charge of the ceremony, so you would need to go to the local court to know what those rules are. Uh, they said the existence of an unreviewable and unreversible power in the jury to acquit and to disregard the instructions on the law as given by the trial judge. They said for more the Supreme Court of California, y'all, this is exclusively California. They said for more than 300 years, jurors have had the power to nullify. Come on, man. They talking about ancient England now. They said this is way, 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 way back. They said for more than 300 years, jurors have had the power to nullify, that is, to disregard court's instructions and the evidence presented and return a verdict of acquittal where the law and the evidence dictate otherwise. They said that the concept of jury nullification is one that permits a jury to ignore the plain letter of the law and administer what the 12 persons as a body regard the socially and more appropriate verdict in a particular case. If we just had one county, just had one county, you could get rid of a lot of foolishness. Just one county, just one unified county, and we agree on this one issue. If there's no injured party, acquit it, get rid of it, nullify it, not dealing with it. The government is not allowed to be the injured party, according to the Bill of Rights of your state and the Magna Carta. They say they do it every day. "Oh, well, we're acting on behalf of the state." Okay, the state didn't make a complaint. They're not the state. When the jury gets there, they're the state. And you can't write fake rules that predict every behavior. Every case would be different, and it's up to the jury to decide the issue in every case. And if there's no injured party, according to the common law, which is the law of the 50 states, then you don't convict people over fake crime. What else? The Supreme Court of California said the common law is still the law of California. They said we never got rid of it. They said it's been the law. They said California rests exclusively upon the common law, which was made the rule of decision at the time of the formation of this state. They said we didn't get rid of it. This is exclusively what we're supposed to be doing. Not fake legislative enactments, not fake judges in a black robe. What else? What else? We see how important this stuff is? They said the grand jury, the California grand jury is an investigatory investigatory, that's not how you say that. Investigatory is an investigatory, I didn't say that right, but an inquisitorial body and takes evidence to determine whether any crimes have been committed. They said the grand jury is supposed to be letting you know. They said cases ain't even supposed to be created. They supposed to be going to the grand jury. They said you're supposed to have a real injured party, and the real injured party would go to the sheriff would go to the grand jury, and then the grand jury would hold a meeting, and the grand jury would say yay or nay. And then if it was a yay, they go to the trial by jury, and the trial by jury would determine the law. See, the grand jury determines the evidence, and then they have a trial over the law and the facts with the evidence presented. They did it at common law. They said so long as at least 12 grand jurors who heard all the evidence. Now, this is different from state to state. Every grand jury, every state does their own thing. So it's very hard to determine states do grand juries. It's not very hard. I just don't. That's an enormous amount of work. But they said the grand jury is the inquisitorial body of a very ancient origin created for the protection of society and the enforcement of law. Who's enforcing the law? Not the police. They said that's not their job. They're not even supposed to be. Let me go back to Illinois. Y'all don't believe me. I did this yesterday. They said Illinois said at common law there was no such thing as a policeman. California said the grand jury enforces the law. I got another thing that says that I don't know if it was a case or a law book. They said that the grand jury, the FBI is modeled off after what the grand jury is supposed to be doing. And why these attorneys don't be telling us this? 'Cause they not your friend. Oh, that's not what I needed. They said policemen were unknown to the common law. They said there was no such thing as a police. They said where they come from. They come from somewhere else. There's no such thing as the police in your state constitution either. I forgot where I was going. What else? What else? What else? I forgot what I'm talking about. Police, grand juries. I was talking about grand juries. Any questions? Any questions? Let me see if I can search grand juries. Who is this? This is they said the prosecutor has the duty to present substantial exculpatory evidence to the grand jury. They said we do require exculpatory evidence during the course of an investigation to be revealed to the grand jury. They said a fully informed grand jury cannot find probable cause to indict. So there's a limitation on the grand jury. They said a fully informed grand jury cannot find probable cause to indict. There is little chance the prosecution could have proved guilty on a reasonable doubt to a fully informed critique. They said improper facts, improper tactics that overzealous they said improper tactics that overzealous or misguided prosecutors have adopted in judicial proceedings. So they said these prosecutors been giving fake cases to the grand jury, to an uninformed grand jury. They said knowing the use of perjury, they give fake perjured testimonies to the grand jury. They suppress evidence to the grand jury. See, this is our fault. They said misstatements of the law to an argument to the grand jury. In cases prosecutors presented perjured testimonies, questioned the prosecutor. You see, these fake people, they want their fake case so they can get paid. Yep, failing. All of these are violations of due process. They said failing to inform the jury of its authority to subpoena witnesses. They said the grand jury can just tell the sheriff to go get people and interview them, operating under a conflict of interest, misstating the law. They say that a bunch of times because that's all they do is misstate the law. Misstating the law, misstating the facts on cross-examination of a witness. California, I read this already, but grand jury is the inquisitorial body of an ancient origin created for the protection of society and the enforcement of law. They said an attorney has no right to give an opinion to the grand jury unless his opinion is requested. Say they work for us. They said, "Did we ask you to speak?" Mhm. Yeah, let's keep it quiet here. We got it, thank you. No, we'll take it from here. Thank you so much. Water, it's water. It's water, it's water. They said the attorney has no right to give an opinion to the grand jury. They said the grand jury is separate from the courts, and the courts do not preside over the grand jury. See, first I told y'all that the jury, the trial by jury are the judges of the law, and that if they feel like acquitting, they gonna quit and can't nobody reverse it. See, y'all don't hear me. They said this is long rooted in centuries of Anglo-American history. They said this is a constitutional fiction or fixture in its own right. They said the whole theory of its function is that the grand jury doesn't belong to the government. It's supposed to be a referee between the government and the people. Why don't they tell us about them? They don't want you to know. They said the grand jury requires no authorization. See, let me tell you what they were supposed to do with that ICE agent up there in was it Minnesota? Okay, well, the grand jury was supposed to say, "Okay, sheriff, go get him," because he acted without constitutional authorization, and now he answers to the people of Minnesota. You understand how nasty this stuff is? They said the grand jury don't require an authorization. If the grand jury say, "Go get the sheriff to go tell him to go pick up somebody," the sheriff gotta go pick up somebody, or they'll do an indictment on him. Corrupt judge, yeah, go pick him up. You answered to us today. Yeah, we don't get it. We don't get it. They said the grand jury requires no authorization to initiate an investigation, nor does the prosecutor require leave to seek a grand jury. They said the grand jury operates without the interference of the judge. Every corrupt cop, every corrupt judge, every corrupt government employee is supposed to be scared of the grand jury. Does that make sense? They said the grand jury swears in its own witnesses and deliberates in total secrecy. They said the grand jury do what it wanna do. They said, the grand jury is deeply rooted in Anglo-American history. In ancient England, the jury served as a body of accusers sworn to discover and present persons suspected of criminal wrongdoing, and they were a protector of citizens against arbitrary and oppressive government action. They said in this country, the founders thought the grand jury was so essential to basic liberties that they provided it in the Fifth Amendment. That serious crimes can only be instituted by a presentment or indictment of a grand jury. They said the grand jury's functions survive to this day. Its responsibilities include the determination on whether there is probable cause and the protection of citizens against unfounded criminal prosecutions. Oh, I'm sure there's a grand yeah, in DC. That they have to have one in the, because of the federal constitution over criminal issues. I don't think they I could be wrong. I think they have to have it in criminal and civil issues, but for sure criminal issues. But in the States, They don't always have to. They're supposed to, but they don't have to. The states are sovereign. So they said, excuse me, the grand jury's historic functions survive to this day. That their job or their responsibilities is the protection of citizens against unfounded criminal prosecutions. Said yada yada yada. They said the grand jury. Here we go. The grand jury is an English institution brought to this country by early colonists and incorporated in the Constitution by the founders. The basic purpose of the English grand jury was to provide a fair method for instituting criminal proceedings against persons believed to have committed crimes. Grand jurors were the people. There were the grand jurors, the people, and their work hampered by rigid procedural or evidential rules. Grand jurors could act on their own knowledge and were free to make their presentments or indictments on such information as they deemed satisfactory. They said in England they were free from the control of the crown or judges. They said in this country, as in England, the old grand jury convened a body of laymen free from technical rules, acting in secret, pledged to indict no one because of prejudice, and to free no one because of special favor. Said the English grand juries were still free to act on their own knowledge if they pleased to do so. They said a Supreme Court judge, no, a circuit court judge, said that he could find no case for the reversing the judgment of a grand jury upon the evidence, upon lawful evidence. Yeah, there's a bunch of stuff. Let's see. They said this thing called the grand jury played some of the most has played in some of the most stirring events in the history of the Anglo-Saxon race. Its effectual protection of liberty of the subject from arbitrary power of government. It has been extravagantly praised as the security of Englishmen's lives, the conserver of his liberties, the noblest check upon malice and oppression of individuals and states. Say the grand jury. So you know what I do? I look up, I don't know if this is, I would check your nearest court and I would search for the Ohio grand jury, the Georgia grand jury, the whoever grand jury. See what the rules are. Go over it. Don't just believe me. Go see what they say about it. See what they're allowed to do, where the nearest grand jury office is, because they got their own office. They're protected by a sheriff deputy. Of the, it should be one in every county, to my understanding. But yeah, any questions? Any questions? All right. Well, I'm gonna get up off of here. I'm not gonna be on here all night. We'll try it again tomorrow, 6:30 Central Time, 6:30 Central Time, 6:30-ish Central Time.